Welcome to the September Tax Roundup. This month, we'll be covering a number of areas that practitioners should have on their radar. Mike will begin with the ATO's summary of key risk areas for privately owned and wealthy groups in the 2026 financial year, as well as the ATO's concerns around the 45-day holding rule for franking credits in the context of newly incorporated bucket companies. And then walk us through the recent Barth Family Trust case where the AAT denied a taxpayer's claim for input tax credits because the 4-year limitation period had expired, and highlight some of the broader timing issues that can arise in relation to GST credit claims. The ATO has released a summary of the key risk areas that it will be focusing on for privately owned and wealthy groups in the 2026 financial year. Mike, what are some of the things that practitioners should be aware of in terms of ATO focus areas?
Yeah, the ATO has released its list of focus areas, I guess, for private groups when it comes to the 2026 year. And look, if you have a look through the list, you'll see that these are the types of things that tend to feature on these types of lists year after year. So in some ways, look, the things that the ATO are focusing on or have said they're going to focus on don't come as necessarily a great surprise. However, there are a few things that did jump out to us as we looked down that list for this year. Let's just have a look at a couple of things in particular that are worth focusing on. First one is, once again, we're seeing the ATO reference concerns around family trust elections and family trust distribution tax. Now, if we take a step back, we often use family trust elections as a way to access certain concessions within the tax rules, just particularly for discretionary trusts, which are a little bit difficult to work with in the context of certain areas of the tax system, but making a family trust election can make your life a fair bit easier in some respects. The downside, of course, to making a family trust election is the potential to trigger family trust distribution tax, which is the case when that trust that's made a family trust election makes a distribution to an individual or an entity that is outside the family group as defined in the family trust election rules. Now, what we're noticing is that the ATO has raised this issue a number of times just over the last probably 3 to 6 months. And look, we pointed this out as part of these updates in the past, but this is just yet another reminder that the ATO really does seem to be focusing in on this area pretty tightly. Now, one of the things that you find if you work with these rules for any length of time is that they are probably more complex than what you maybe first thought when you first started looking at and working with these rules. There are elements to these rules that are more complex than you might think. There are elements to the rules that are more narrow and restrictive than what you might think as well. And so, look, the warning has been put out there many times now that this is an area where we need to make sure that our house is in order. We need to make sure that the way we're looking at these rules is actually technically correct, and to make sure that we're taking a big picture view as well. I think where people get into trouble is where they're taking a short-term view in terms of making an election to fix a short-term problem without necessarily taking a step back and realizing that this could have wider implications and down through many years, through a number of generations. We could be creating a pretty big problem if we're not careful. So that's one thing. Just as a side note on that, some of you might be aware that the ATO has some reasonably comprehensive guidance around family trust elections and that kind of general area on its website. That guidance has been significantly updated over the last little while as well. So not a bad idea to take a look at the latest guidance from the ATO in that space. The ATO does a pretty good job of explaining a few concepts in the current version of the guide that maybe weren't explained as well previously. And you'll see towards the end of the ATO's family trust election guide that there are some cascading worked examples dealing with what you might think of as a pretty typical private group, where over time you can see that these problems will sometimes naturally develop and why it pays to be so careful as a practitioner when we're assisting those private clients. So that's the first thing that jumps out, not because it's brand new, but because the ATO keeps talking about it. We know that this is a focus area. One of the other things that jumped out was a very brief comment from the ATO saying that they're focusing on situations where groups are restructuring in order to access concessions that they would not otherwise be entitled to. Now, it's a pretty vague comment. The ATO doesn't really expand on kind of what the major concern might be, but look, I suspect a lot of this is around things like the small business CGT concessions. There was a case going back a number of years ago now where a group had restructured quite significantly in order to access small business CGT concessions. And when that was looked at by the tribunal or the court, basically it was found that, yeah, on the face of it, it looked like the concessions would be available, but Part 4A was an issue. The restructure that had occurred couldn't really be explained by non-tax reasons. It seemed to be a pretty clearly tax-driven restructure aimed at accessing concessions that would not otherwise have been available. Now, that doesn't mean that you will miss out on concessions just because there has been some sort of group restructure. That's not the case. Part 4A particularly is far more complex than that, but it is just an area we need to be quite careful about. We need to be mindful of the fact that the ATO has raised this as a concern, presumably because they're seeing things happen out there in the real world that maybe they've got some concerns about. And so we just do want to be a little bit careful. If you do have clients where maybe they're on the margin of accessing or not accessing certain concessions, certainly there might be a temptation to see, well, what steps could we take to make sure that they do access those concessions? Just remember that we have to have a think about anti-avoidance rules. Part 4A, we need to just consider the risk that might be attached to any steps that are undertaken. So a couple of things in particular that jump out of that list in which we just want to be paying some extra careful attention at the moment.
Thanks, Mike. The ATO has raised a specific issue around the 45-day holding rule for franking credits in the context of newly incorporated bucket companies. What's the issue that the ATO is worried about here?
Yeah, there is that one other item that did jump out to us when we're looking at that list of ATO focus areas. And it was, again, a reasonably vague comment around a concern where we have frank dividends being distributed to a recently incorporated corporate beneficiary. Now, looking at that ATO list of focus areas, it might be a little bit hard to figure out what exactly is the ATO's problem here. What is it? What's the issue that they're trying to raise? And if we just take a step back, we have been hearing throughout this year in particular that the ATO does have a real concern in connection with situations like this. But this is the first time, certainly, we've seen anything in writing from the ATO really kind of pointing out that there is that concern. So we've been hearing rumblings. We've heard from a number of knowledge shop members that the ATO has raised this with them as part of review activities. But look, it's the first time we've seen anything from the ATO actually written down, kind of expressing that concern. What is it actually here that the ATO is concerned about? Well, the scenario that the ATO seems to have a problem with is when a company pays a franked dividend to a shareholder that happens to be a trust, and the trust then distributes some or all of that franked dividend through to a corporate beneficiary. Now, that in itself isn't the problem. The problem is where the corporate beneficiary didn't exist at the time the original dividend was paid by the original company. So the sequence of events typically that we'd be looking at here is that a company declares and pays a dividend in favour of a shareholder that happens to be a trust. There's then a new corporate beneficiary or bucket company established. And then sometime later in that year, the trustee takes steps to appoint the franked dividend income through to that fairly newly incorporated bucket company or corporate beneficiary. Now, the problem here is around the 45-day rule for accessing franking credits. In order for a shareholder or an ultimate beneficiary of a trust who's received franked dividends indirectly to access a tax offset for those franking credits, they need to pass a series of integrity rules, one of those being the 45-day holding rule. And basically what that rule is there to do is to say, look, yes, you might have received a franked dividend directly or indirectly, but you can't access the tax offset for the franking credits unless you've held those shares at risk for a 45-day period. Now, these rules are pretty complex, and there's a bit of a checkered history in terms of how we approach these rules, given that, in a sense, they were actually taken out of the legislation, but they're kind of still active in a bit of a roundabout way. So it's a bit of a muddle, but look, these rules still apply, and we need to be really careful when we're working through them. The ATO's view is that the company, the corporate beneficiary, the bucket company, it can't pass the 45-day rule here because it didn't exist when the dividend was originally paid. And that's despite the fact that the trust might have held the shares for more than 45 days, and despite the fact that the trust might have made a family trust election, which is something that we often have to look at doing in order to protect those franking credits. Now, is the ATO right or wrong? Well, I couldn't tell you absolutely for sure. These are incredibly complex rules. very technically difficult to work through, and it's difficult to find anything with any kind of real confidence in terms of exactly how the rules should apply to a situation like this. But this does seem to be the position the ATO is taking, which means that you might disagree, but if the ATO comes across it, there's every chance, probably a very high chance, that the ATO will challenge the treatment you've adopted, and it would then be up to you to either fight the ATO on it through the tribunal or the courts, or just accept it and kind of give up the franking credits. So, yeah, whether you agree or not, it's important to understand this is the ATO's position at the moment. Now, you won't quite see that from the guide that we're referring to, but look, piecing together all the bits and pieces that we've been hearing over the last year, yes, that does seem to be the ATO's position. Now, again, whether you like it or not, whether you agree with it or not, it is important just because it will potentially be a factor in terms of trustee decisions around distributions. Yeah, do you make that distribution to the corporate beneficiary that's been set up quite recently, or do you just wait, distribute to other beneficiaries this year, and then next year start distributing franked dividends to that new corporate beneficiary? It's really about risk management, isn't it? It's about having a conversation with clients around, kind of where they stand in terms of their appetite around risk, their appetite around a dispute with the ATO, and making sure that they're able to make an informed decision as they do that, going into the whole thing with their eyes open. So, as I said, it's something that jumped out to us because we've been hearing some talk around this particular concern of the ATO, just hadn't seen it really documented anywhere. Look, it's not documented in any overly technical way, but the fact that the ATO is referring to it in this guide suggests this again is an area we just want to be really careful about. Now, leaving that aside, the 45-day holding period rule in general is a complex one to work through. You would need to be looking at it pretty carefully anyway. As I said earlier, if we've got franked dividends passing through a discretionary trust, we have limited options in terms of how we protect those franking credits. Family trust selection might be one of them, but as we've already talked about, there's risks with making family trust elections. We've got to think about the longer term, not just the shorter term. So certainly some areas to be careful about, some things that the ATO are likely to be focusing on at the moment. And it's good just to go into these things and approach these issues with the understanding that these are ATO focus areas.
Thanks, Mike. The ART recently handed down a decision in the Barth Family Trust case, which denied a taxpayer from claiming input tax credits where the 4-year period from the due date had passed. And can you summarise the decision and the key issues?
Thanks, Amy. So in the recent Barth Family Trust case, the ART confirmed that the taxpayer was not entitled to claim input tax credits under Section 93-5 of the GST Act in relation to returns lodged more than 4 years after the due date. As background, the Barth Family Trust operated a swimming pool construction business and was registered for GST since July 2000. In around 2011 or 2012, their computer was stolen, which meant that they didn't lodge their GST returns electronically from then onwards. While they tried to lodge by paper, it was only after they purchased a new computer and obtained another Oz key in March 2018 that they lodged their outstanding GST returns. As a result, there were late lodgements for periods dating back several years, being 4 to 5 years after the statutory deadlines. So the primary issue in the case was whether the trust's entitlement to input tax credits had been extinguished under Section 93-51 of the GST Act. On this, the tribunal confirmed that Section 93-51 imposes a strict 4-year time limit on claiming input tax credits, which applies regardless of whether assessments had been issued or not. The late lodge returns in 2018 for the periods dating back to 2012 were more than 4 years overdue, and therefore the tribunal upheld the view that the trust's entitlement to input tax credits for those periods had been extinguished. Secondly, the trust argued that despite the late lodgements, it might still be entitled to the credits based on communications with the ATO suggesting a possible extension or deferral of the lodgement deadline. So the tribunal examined whether these communications, including phone calls and written exchanges, amounted to an acknowledgement or approval by the ATO that the lodgements were within a deferred period and thereby suspending or extending the 4-year time limit. However, it found that the communications were merely records of the trust's agreement to lodge the returns by certain dates, and they didn't constitute any formal or effective approval of the deferment of the deadlines. So consequently, the tribunal confirmed that Section 93-51 of the GST Act applied strictly, and the 4-year time limit period had expired for the lodged returns. As a result, the input tax credits claimed in those late returns were disallowed. The tribunal's decision here affirms the importance of the timely lodgement and clarifies that general correspondence with the ATO doesn't extend or defer the statutory time limits under Section 93-51.
Thanks, Anne. What are some of the other practical issues to note in relation to the timing of claiming GST credits?
Thanks, Amy. So as shown in the case, Div 93 sets a strict 4-year time limit for claiming input tax credits. The ATO also has a miscellaneous tax ruling, MT 2024-1, which looks at time limits for claiming input tax credits under this section. So consistent with the case, the ATO's approach is that the 4-year time limit is to be applied strictly and is only altered if the Commissioner grants a formal extension to the due date for the relevant BAS. At a high level, this strict interpretation can produce harsh and often unfair outcomes for clients due to the timing mismatch between the 4-year input tax credit period and the 4-year BAS review period. Businesses have 4 years to amend their BAS statements, which is known as the BAS review period. Meanwhile, under Div 93, this introduced a separate 4-year time limit on claiming input tax credits, known as the Input Tax Credit or ITC period. So in theory, this was meant to align with the GST liability rules. However, in practice, there's a mismatch between the two periods. The BAS review period starts when the BAS is lodged, while the input tax credit period runs from the due date of the BAS in which the credit first arose. So this mismatch means that taxpayers can lose their entitlement to credits even while the BAS itself is still open for amendment. So the ATO in its ruling, and as shown in the ART case, takes a strict approach. Once the ITC period expires, the entitlement is lost forever. It can't be revived by requesting an amendment, applying for a private ruling, or making a voluntary disclosure. The only way to preserve it is to lodge a valid objection within the 4-year ITC period. So as an example, a business that should have been registered for GST in 2018 but didn't register until 2023. When the new accountant prepares and lodges the overdue BASs, the ATO will accept the GST liabilities in full, even those going back more than 4 years, because the BAS review period doesn't commence until the BAS is actually lodged. But because of Div 93, the client isn't entitled to claim the input tax credits relating to acquisitions in those earlier periods where the 4-year ITC period has already expired. The result is that the business has to pay several years' worth of GST on its sales, but is denied the matching credits on its purchases. And we see this kind of situation quite often. For example, where unclaimed credits are discovered late, where the ATO takes too long to process an amendment request, or where late BASs are lodged. In each case, the GST liabilities survive, but the input tax credits can be time barred, often leading to an unfair outcome for clients. So what can practitioners do? So firstly, always check both timeframes, the BAS review period and the input tax credit period under Div 93. It can't be assumed that they're the same. And secondly, if you identify any unclaimed credits that are close to expiry, it's important to lodge a formal objection straight away, as that's the only way to preserve the entitlement.
That concludes our September tax roundup. The key issues this month are the ATO's continued focus on compliance in private groups, particularly around franking credits integrity and the strict operation of GST timing rules, as confirmed in the Barth Family Trust case. Both developments serve as timely reminders for practitioners to stay across the detail and keep client structures and processes up to date. As always, Knowledge Shop is here to support you with the tools, training, and technical updates you need to stay on top of these changes, from expert-led alerts and work papers to practical CPD, member-only Technical support being part of Knowledge Shop means you can navigate these issues with confidence and efficiency. Thanks for joining us, and we look forward to bringing you more updates next month.